I'm commonly asked in my practice, what is probate and do I actually need it? Probate is essentially where you validate or formalise the will. The common example that I give to most of my clients is that if you as the executor go to a bank with a deceased person's death certificate and will and ask for them to release the funds to you, the bank does not know if this is in fact the last person's will. I mean, it may well be that there was a will made after this, or the deceased person did not have capacity when they made that will, for example. The bank will want some type of assurance that this will that you're presenting to them is in fact the deceased person's last will. So they will make you obtain a grant of probate of the will. What that process generally includes is advertising in the Queensland Law Reporter, which essentially says that you intend to apply for a grant of probate of this person's particular will of a certain date. If someone doesn't agree to that, they can lodge a caveat in the Supreme Court to stop that process happening. 9 times out of 10, there is no objection lodged, and the executor can then apply to the Supreme Court for a grant of probate. The court then will generally take about 4 to 6 weeks to process that grant. That will then allow the executor to be able to obtain all the assets of the deceased person and comply with their obligations as an executor of the estate. Once the executor has the grant of probate, they are then able to go to places such as banks, share registries, or even nursing homes to provide them with a copy of the grant so they can release the assets to the executor. The executor doesn't need to obtain probate of the will in every estate. It really depends on the assets that comprise the estate at the time. In order to determine if you need probate or not, we suggest you contact us for our free, no obligation claim assessment.